Let's take a look at enforcement of arbitration agreements. Agreements requiring employees to use arbitration rather than the courts as a means for resolving employment law claims are generally enforceable. The Supreme Court decided that arbitration agreements between employers and employees are covered under the Federal Arbitration Act and thus generally enforceable. The FAA, enacted by Congress in 1925, requires courts to enforce most written arbitration agreements. The court's evident enthusiasm for arbitration does not mean that arbitration agreements will always be enforced. Even with a signed arbitration agreement in hand, an employer is still subject to administrative proceedings and possibly a lawsuit brought on by half of an employee by an administrative agency. Arbitration provisions in collective bargaining agreements will not bar litigation over violations of individuals' legal rights unless the contract language clearly and unmistakably requires arbitration of both legal and contractual dispute. To meet this standard, a collective bargaining agreement must, at the very least, identify the specific statutes the agreement purports to incorporate or include an arbitration clause that specifically refers to statutory claims. Fundamentally, arbitration agreements are contracts. Courts decline to enforce contracts when fraud is involved, the contract was entered into under extreme duress, or the contract is unconscionable. Contracts are unconscionable when the contexts of the agreement unreasonably favor the more powerful party. Arbitration agreements have sometimes not been enforced by the courts on the grounds that they are unconscionable. Some courts may also inquire into the education and legal sophistication of the employee and whether details of the agreement were adequately explained or hidden away amidst copious fine print. The question of enforceability most often turns on the contents of these agreements. One area of particular concern is the procedure for selecting an arbitrator. An essential requirement for a fair arbitration is neutrality. Agreements that give the employer effective control over who can arbitrate a case or require the use of arbitrators with business ties to the employer are unlikely to be enforced. Limitation periods for filing arbitration claims that are shorter than those that would apply to court proceedings have sometimes, but not always, been deemed unconscionable. However, courts also recognize that the relative informality, rapid resolution, and lower cost of arbitration are precisely what makes it an attractive and therefore do not require the arbitrators monitor the proceedings and remedies of litigation. Under the FAA, arbitration agreements are not invalid simply because they contain language disallowing class-wide arbitration, even in cases where claims by individual plaintiffs would be prohibitively expensive. Nevertheless, it is currently an open question whether, despite being permissible under the FAA, prohibiting employees from banding together to bring arbitration cases violates the National Labor Relations Act. The NLRA broadly protects collective action by employees. This includes the right to unionize, but it might also include participating in class-wide arbitration.